Welcome to our final video in our series about decision-making options in Wisconsin, presented by Davis & Plato Law Firm. In this episode, we will be providing a walkthrough guide to guardianship. Guardianship of the person is a legal arrangement where a court appoints an individual to make personal decisions on behalf of another person who is unable to make those decisions for themselves. The person needing guardianship must be at least 17 years old and 9 months when the guardianship petition is entered. In the guardianship process, an individual's need for assistance in decision-making or communication is unable to be met effectively and less restrictively through appropriate and reasonably available education, training, support services, healthcare, or other means that the individual will accept. Guardianship is the most restrictive option for a person with a disability who requires a much higher level of support than other available services can provide. The guardianship of the person is ordered by a court, and the appointed guardian exercises various rights and makes important decisions for the individual. However, the guardian of the person cannot make any financial decisions on behalf of the person unless they are also the guardian of the estate. Before proceeding with the guardianship case, it's important to know these key terms. The petitioner is the person who is requesting guardianship, for example, a family member, friend, or healthcare provider. The proposed guardian is the person who will be the decision maker if the court approves, and the proposed ward is the person who is under guardianship. The term ward is outdated and not person first. However, it is the legal term used. We will refer to the ward as the quote individual throughout this presentation. The guardian ad litem is an independent attorney who represents the individual's best interests and meets with the individual and guardian to advise of rights and collect collateral information. The advocate or adversary counsel is appointed if the individual objects to guardianship, representing the proposed individual in court proceedings and following the individual's directives. Finally, there is a required county notice, which includes the County Corporation Council in the County Department of Health and Human Services, or DHHS, if the individual is receiving public benefits. A primary source of evidence in guardianship cases is the examiner's report, which involves a physician or psychologist, or both, examining the individual and issuing a written report. Prior to the examination, they will read a statement of rights to inform the individual of their rights. At the hearing, the physician will answer questions about the individual's disability and needs and whether they meet the standards for guardianship. The physician will also give their medical opinion about the individual's ability to exercise their rights and address the need for protective placement if necessary. Legally, guardianship of the person is granted when, because of their impairment, the individual is unable to receive or evaluate information and make or communicate their decisions to such extent that the individual cannot meet essential requirements for their health and safety. Additionally, it's important to note that Wisconsin law includes multiple categories of disability, including developmental disabilities such as autism, serious and persistent mental illness, degenerative brain disorders such as Alzheimer's or dementia, and, quote, other like incapacities such as a traumatic brain injury. In the context of guardianship, there are 3 types of rights. The first are rights that are taken away in full from the individual by the court, such as serving on a jury, executing a will, and voting in an election. The next are rights that may be expressed with consent, meaning the individual can exercise these rights if the guardian says it's okay, such as consent to sterilization, consent to marriage, consent to bone marrow, organ, or tissue donation, and applying for licenses such as driving, hunting, fishing, professional credentials, and other licenses. Finally, there are rights that can be transferred to the guardian either fully or partially, including healthcare decisions such as treatment providers, social services such as enrolling in programs like family care and Social Security, educational decisions like IEP and post-secondary education, vocational decisions like DVR, protective placement, receiving notices, divorce, and mobility and travel decisions. The guardian can also advocate for the individual in court proceedings, but may not handle things like contracts or money. Finally, let's talk about the main differences between full and limited guardianship. In full guardianship, all rights that can be removed are removed, and all rights that can be transferred are transferred. However, in limited guardianship, the individual may retain some rights. The individual may also be given input into decision-making, and the guardian's authority may be limited. Moreover, a guardianship does not have to be all or nothing. It can be individually tailored to allow the individual to retain the most rights possible and to maintain a voice or input on important decisions. Based on the information provided, are you interested in learning more about guardianship for someone you care about? Check out the resource in the caption of this video for more information, which include guides from the Guardianship Support Center and the Marquette Volunteer Legal Clinic. While applying for guardianship can be done on your own, it's important to note that the guardianship process is often complex, so it's helpful to have an attorney on your side. If you're interested in a legal consultation about guardianship, contact Davis & Plato by emailing us or visiting our website today.